Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Cost of these applications shall be imposed. We grant leave for appeal, typed proceedings and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
Most obliged, my lord, and I have an
Much obliged, my lord. We want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my lord.
Thank you.
My name is Achille Dudley for the Deputy President, and I wish to make an application. The application I wish to make is called the Matthew Paper Injunction. Matthew Paper International, quite a famous case. In the common law, it's called the Erin-Ford Injunction. Lord, the Matthew Paper Injunction operates on quite a simple premise, the premise of human vulnerability. In the case of Erin-Ford, where that injunction originates, Justice Makery, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Yet, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings. And that application comes up on the 6th of November 2024. Lord, operating on the premise of human fallibility, the foundation of the Erin-Ford or Matthew Paper Injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered illegal. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even when he needed that, we ask you to issue a Matthew Paper injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when you're next before the Court of Appeal. Thank you, my lord.
We also have a moment by the chair.
The black rule, okay.
Yeah. My lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Mutunga Rules. I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, binds this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission, Mr. Jero has referred to an application for which he's seeking some orders pending, but we haven't seen any application.
Yes, Your Lordship, if Mr. Kamoto was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
If I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either he's referring to E554, E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of a epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for